going to get started. All right, here we go. Showtime. 40 years of family court, a retrospective. What a thrill to have over 40 years of continuous leadership in the family court here, one place, one time. I hope it happens many times hereafter, but I'm thrilled that Judge Cass, who, as we all know, at times acts in family court, was agreed to moderate this. He has told me it'll be on a high level, and to make sure that's the case, Tori Ergang's going to introduce, for the record, Judge Cass, who in turn will introduce our distinguished guest. Tori?
So my job is to introduce a guy that needs no introduction in this room, but Judge Cass has been the judge for Chautauqua County Surrogates Court since 2000, and prior to that, he did a number of very interesting legal things and probably worked with many of you in this room. I know we are close to Judge Cass at the Community Foundation because he served on our board during a prior time in his life. So without further ado, the family court panel.
And to get started, the first thing I'd like to say is a quick shout out, of course, to Lydia Romer and Lana Houston, my former chief clerk and my current chief clerk, because I really feel like a chief clerk for a minute, because now I know what they went through. I have these judges, and I'm going to ask them questions, and I have no idea what they're going to say. So I know what Lydia and Lana go through every day. So anyways, here's my plan. I have to tell you that I had an opportunity to meet with each one of the judges, and I found their history absolutely fascinating. So my plan today is really to personalize them, to give you kind of their backstory through them. After we complete their short backstory, then we'll move into the way family court was in 1978 when Judge Hartley took over, and then we'll move into Judge Claire and how things have changed, and then we'll, of course, move into Judge Piazza and Judge Sullivan, and you'll see how really family court is continuing to change. A lot of this will really focus on the judges. There are a lot of fascinating cases and stories each one of them can tell about cases, but really we're fortunate to have such great people, and with that I'm going to start. So Judge Hartley, give us a little bit of your background.
How far back do you want to go?
Well, I thought one of the most interesting stories about you when we began to talk was really you were born in Jamestown, and your mom and dad married when?
They were married in November 1941.
Just before World War II.
Correct. They had actually just returned to Jamestown just a few days before December 7th.
And then you were born in 1943?
Yes.
And your dad went off to seas?
Yes, my father enlisted in the Army. He had applied for OCS in the Marine Corps and would have been accepted, except he was old. He was too old by the time he would have concluded his training, so they would not accept him there. So he enlisted in the Army and became a military police officer.
And when did he ship out overseas?
He was shipped out sometime in the spring of 1944. We don't know the exact date because when they decided you were going, they just put you on a boat and off you went. So he was in England and then France. Shortly after D-Day, he crossed over in France and stayed in France until Germany surrendered. He received a field commission to second lieutenant. And when the war was over in Europe, his outfit was transferred to the Pacific Theater to prepare for the then presumed invasion of Japan. And he landed in the Philippines in first week of September, which was actually just shortly after President Truman gave the order to drop the bomb, and finally they surrendered, but he and his outfit were sent on to relieve troops that had been over there for some time.
And I know this is very personal, but your first memory of your father was what?
My first memory of my father was, I know some of you know, my father passed away in the Philippines approximately 2 weeks after he landed there. And my mother was given the option of having him buried in the cemetery that was being created in Manila. If any of you have ever been to the military cemetery in Honolulu, which I believe is known as the Punch Bowl, it's very similar to that. It's just kept immaculate. I had an opportunity to visit the Philippines in 1976 as part of the Rotary Group Study Exchange Program, and I was in Manila for several days and had a chance to go over to that cemetery. The groundskeepers over there, they actually line up for inspection every morning before they go out and manicure the lawns. And when I say manicure, that's pretty much what they actually do. But the first memory I have of my father was would have been in March of 1949 when they brought my father's body back to Jamestown. And I remember being at the train station when he was brought in, and I have another memory of him being at this funeral home, Henderson Lincoln Funeral Home at the time, and asking my mother why they wouldn't open the cemetery or open the casket so I could see my dad. I was 6 at the time. And the last memory I have of that was the next day up at Soldiers and Sailors Circle when they gave him they buried him with full military honors, and the gun salute sort of shook me up a little bit that time. But those are the 3 memories I have of my father.
Then you grew up in Buffalo?
Yes, my mother had been from Buffalo. She had moved down here after college, and that's where she met my father. When he enlisted, we moved back to Buffalo and spent time between Buffalo and Farmersville, New York. Some of you may know that thriving megapolis over there. Beautiful place. My grandparents' home was over there. And so I grew up in Buffalo, and actually a month after we got my father back and buried him at Soldiers Sailor Circle, my mother remarried in April of 1949. And that's how I ended up growing up in Buffalo.
How would you end up back in Jamestown?
I maintain a very, very close relationship with my father's family. They very much like my dad. I never called the man that my mother married a stepfather, and I never will. So my dad stayed very close to my father's family, and I would come down here very frequently throughout my growing up years. And when I was attending law school, my aunt had married George Matthews, who was the proprietor of the Matthews and Miller Men's Store, which a few of you may be old enough to still remember. And he had been a town justice in town of North Harmony. and he had gotten to know the then town justice from town of Carroll, a Willard Cass Jr. And he introduced me to Bill Cass, and I had just concluded my second year, or was in my second year of law school, and he gave me a job as a summer intern in his office in the summer of '66. And the next year, when I completed school and finished the bar exam, I was offered a position in Buffalo, and Bill also offered me a position, and I ended up taking that one. Little did I know at the time, the reason that he was looking to hire somebody in 1966 is because he already had I believe it was a month-long trip to Africa planned for 1967. And I can tell that many of you know what he was doing over in Africa in 1967. I won't tell you what he brought back, but he had some very good times over there. And that's how I came to work for Bill Cass, because he needed somebody to run his office for a month, which I did about 4 or 5 months after I was admitted to practice. So that's how I got back to Chautauqua County, because Bill Cass wanted to go hunting in Africa.
And you ended up as an assistant public defender as well? What year was that?
Early 1968, the then public defender was Bill Arison, who was the second public defender for Chautauqua County. George Rogers had been the original public defender, and when he retired, Bill Arison was appointed, and he appointed as his first assistant a young attorney by the name of Stan Lundeen, whom some of you may know, and I was asked to join that crowd, and the three of us were the public defender's office at that time, and it was my job to appear in all of the justice courts and both city courts in the county, handling all of the misdemeanors in the county.
Now back at that time, who were the judges? Who was the Supreme Court judge and the other judges?
Judge Rollin Fancher was the Supreme Court justice. The surrogate was McKinley Phillips. The county court judge was Judge Edwin O'Connor, and the family court judge was Judge Palmer.
Now that's interesting, because we had this little discussion before, and what year did family court really start in New York State?
Family court in New York was established in 1962, I believe.
And before that, what was the court?
Well, those counties that had one it was called the Children's Court, and not all of the counties in the state did have one. Chautauqua County did have one. I was asked an interesting question this morning whether or not that was an elected position, and frankly, I don't know. But I do know that when the family court was created, that one of the agreements that was reached in the legislature in order to get the Family Court Act passed and the court established was the mayor of the city of New York had always appointed the judges to the predecessor to family court, and they apparently insisted on retaining that power. So that's why, to this day, family court judges in New York City are appointed by the mayor, and in upstate, they are, of course, elected. Some of you may recall or have heard the term two-hatter or three-hat judge, and in counties where there was no separately appointed family court judge position, the county judge by designation was the family court judge. And in many of the smaller upstate counties, I believe Allegheny County would have been one of them, Wyoming County was, where they only had a county court judge. That judge would also be the county surrogate and family court judge.
So I want to explain this to the audience as well. In 1972, when my father was the surrogate, how would he get his budget to run his office, and when did that change?
At that time, the counties were still in charge of the county courts, the county level courts, county court, surrogate court, and family court. And the budgets were all allocated by the county. County set the salaries for everyone, all the judges and the court staff. And it was it was by 1978, the Office of Court Administration had been formed, and the state came in and very graciously offered to take all of the salary burden off of the counties so that it would save the counties a substantial amount of money. However, along with overpaying the judges, they also took over collecting all of the fees, which in surrogate court and county and Supreme Court was quite a bit of money when you consider everything that was filed in all of those courts. The only court that did not have, and to this day does not have, a filing fee is the family court.
So what year did you run for judge?
1978.
All right. Now I'm going to jump over to Judge Claire. And this is a fascinating backstory as well. And because where's home for you originally, Judge Claire? Where did you grow up?
Massachusetts.
And
Massachusetts.
and tell us how you worked your way to Chautauqua County.
Very brief. I was a resident of New York State at the time that I went to law school, and I was putting myself through law school, so I went to UB, which was the only state law school in the state, and I was going to apply, well, I did apply for jobs in Alaska. That's where I was going to go after graduation from law school. And
Pick Jamestown because it was colder?
Yes, exactly. One day I was in the law library, and I think I was doing some research, and Bob came through, and I don't think we were dating then. I can't remember. But I remember he said, "What are you doing?" And I said, "I'm looking for jobs in Alaska." And I said, "What about you?" And he said, "I'm going home to Chautauqua County." And I said, "Where's that?" And of course, you know the rest of the story. I never did get to Alaska, and we ended up getting married and moving here.
But I think when you started at UB, you were one of the first big class of females, right, of women.
We were the largest class of women at the time, the largest being relative, since we were pretty small.
About how many people?
There were about 180 people in our class, and there were 30 women, and that was considered huge.
And I have to ask these questions because, as you've heard the background of Judge Hartley and the background of Judge Claire, I mean, those concepts shaped their futures as well. And things that I learned I just almost couldn't believe. Like, would you tell the story of the student lounge for the UB women?
Our freshman year of law school, women were not allowed in the student lounge. We had to use the ladies' room, which had one cracked pink love seat that sat 2 people for the 30 of us. And we asked why we weren't able to use the student lounge. And they gave us some answer that was frustrating, but also very entertaining. Something about male students not being able to study because
You
they were,
distracting.
yes, if we were in the student lounge. Yes.
And then there came a time that you took a job in Albany?
Oh, right. After law school, I went to work in Albany.
And can you tell what you did there and what was going on?
I was a staff attorney for the Governor's Health Planning Commission.
And this is the time of Karen Ann Quinlan and what?
It was the time of Karen Ann Quinlan. I helped write the definition of death bill, and the commission met with the legislature. We used to take the train down to New York City and meet with them and the committee that was in charge of presenting the legislation and negotiate the actual wording for all these bills that related to health, mental health, social services, that type of thing. It was a very fascinating experience.
And again, I want to ask this question. When you were applying for jobs at that time, what was it like to be a woman applying for jobs, and in what year would that have been?
Well, there were several times I applied for jobs, I guess historically, when I first graduated in '75, and when I moved, we moved for 2 years to St. Lawrence County, and then again when we moved to Chautauqua County, which would have been '78. There were no laws at that time that prevented discrimination. So it was relatively routine to be asked questions like, what kind of birth control would I use? What kind of clothes would I wear? Very insulting and intrusive questions. I could go on, but my favorite was the time I was asked, what would I do if my husband was home sick with a cold?
And so eventually, you ended up here in Chautauqua County,
Yes.
and you started to practice, and what year was that?
In Chautauqua County. Well, actually, we moved back here at the end of '78, and I think I started in January of '79.
And can you tell the audience what it was like to be one of the first women to practice law in Chautauqua County at that time? How were you treated? I mean, what it was like?
That was a long time ago. There were issues, but I don't think of them that much anymore. I encountered some hostility. For a period, I was the only woman practicing law. There was a woman already practicing, Julie Wilson, when I came here, but she left to go to divinity school. There were issues from time to time, but I just worked past that.
And you really became known as a tough litigator. In fact, you had a case with the Lutheran Social Services, a case of sexual discrimination that went all the way to the Court of Appeals?
Yes, that case went on for a long, long time. I think it was almost 10 years, actually, that it was in litigation. And it did go all the way up and set the standard at that period of time for the single largest award in New York State history for pain and suffering. And that award stood for about a dozen years before it was topped.
And there came a time also that you were a court attorney for Judge Gerasi.
Yes,
And what year did you start there?
January 1st, '92.
1992. And then what year did you eventually become the family court judge?
98.
1998. So, Judge Piazza, give us a little background of you.
Well, I was born and raised here in Chautauqua County, graduated from Southwestern High School in 1985. Graduated from the University of Buffalo in '89. I went to law school at the University of Akron, and after my first year of law school, I clerked for Chuck Hall in the summer, and it went very well. He had me come back the next summer, and he told me if I passed the bar, I had a job. So I was very, very fortunate. It was always my dream to come back to Chautauqua County. My family is from here, and I did pass the bar, in case anyone's wondering. And I worked with Chuck, and we were together over 20 years, and we had just a wonderful time together.
How did you get interested in family court?
Well, Chuck is to blame for that too, because he was a very active law guardian, and he told me that he thought it might be something I would enjoy, and he said it was a very important program, and he was right. It became one of the most fulfilling parts of my practice, and I was in front of Judge Willard Cass, Judge Hartley, Judge Claire, you, and did everything from adoptions, custody, visitation, abuse, neglect, had even a juvenile murder case. So spent a lot of time in family court. You remember that one.
I'm not likely to forget that one.
Okay, and Judge Sullivan, a little bit of your background.
Well, I too grew up in Chautauqua County. I'm sixth generation here. Our family settled in what's now the abandoned Glasgow Park. And at the time when they separated, some Sullivans went into Stockton and the rest came down to Fredonia. My family came into Fredonia to work the railroad. The other Stockton side ultimately produced Bob Sullivan, the district attorney, and my side ended up with a family court judge. Before I was practicing law, I became a volunteer fireman in Fredonia. I actually studied for the bar sitting at the fire hall, and that had become a pretty important part of my life. I almost went and got my helmet today when I got here, thinking I would need a hard hat to come in the front door, and then they showed the sign to come back here. But I probably had, well, you were asked how you found your way to family court. Three of my former county attorneys that I worked for are in the room, and I guess I have to be honest, they would tell you that I was the most reluctant attorney. I was the first backup for everybody that was hired to do family court out of the county attorney's office. And I had really reached the point that, all right, if I have to go down, you have to give me something.
Tell me, just so we can set the context, you were county attorney's office from when to when?
That would have been 85 to 92. So in order, I think Andy Goodell, Betsy Steger, and Steve Abdella. And worked for those. Bob Laughlin was the first county attorney for us all, and he's passed since a few years back. But the other three are here, so I have to be honest when I say it was reluctant to go down to family court. I had the nicest office furniture of any of the attorneys in the county attorney's office because I was able to take somebody's client chair or desk chair, whatever, if I had to go down to family court. Had no interest in being there. It was like I wanted to come back home. I was going to do litigation and real estate and estates and have a great practice. Ultimately, Judge Hartley found out that I was brokering to come down to his court. And after during a calendar, he said, when I'm done, I'd like to speak with you. And I said, well, I'll come back down. So I went down, and he's sitting at his desk, and he looks up. So what did you get today to come to court? And he assured me it's not that bad to go there, and we had some conversation, and I continued to go down to family court as a fill-in. When I went into private practice, I was down there one day just before I left the county attorney's office, and the judge was nice enough to say, here's a couple of videotapes, pick a couple you want to watch, and you'll become a law guardian. And then we can put you on cases, you'll get some trial experience, and you'll be off and running. I'm like, oh, okay. I took them home. I meticulously took my notes, and I still have the notes from those two videotapes, because I didn't know if anybody was going to question me after. But I was a law guardian at that point, so started doing work in the court, and it wasn't long after that I had a first couple of children that I represented, and that became the place I wanted to be, as opposed to the place that I had to be compensated in addition to my regular pay to go to. But, and then I had the fortune of then, with the changes in the judge and then with the treatment court coming about, being asked to be on the panel for our treatment court when Judge Claire opened that.
Yeah, why don't you tell how that came about? How
Well-
that changed your mind?
Well, I don't even know if you know the story. One day, we had to have regular meetings to put the program together, and I had missed a couple of meetings, and Judge Claire asked me to come to the office, and I came in, she goes, Mike, I really need you to commit to being at the meetings, and if you can't do that, we're gonna have to try to find somebody else. And she goes, and we've got an out-of-town training coming up, and it's gonna be Toledo. And as I'm trying to get the words out to say, you probably ought to find somebody else, she then says, but then our next trip will be to Reno. And I'm like, well, I'm all on board. So we stayed on and had a great 12-year run with the court running, with 3 years before that and getting it prepared and going. So I look to the two that sit here, and clearly, one changed my mind about family court and made it a place that I was happy to go to, and then Judge Claire involving me in the initiatives that she was involved in over the years. Both of them brought it around where ultimately I am where I am today.
And before we go back and kind of set the stage of what family court was like, did you take any notes when you watched those videos?
Oh, yeah. I had them, and I kept them, and when I was cleaning my office out to come to Mayville, I found them. They were still there.
2016.
Oh, yeah. I never knew somebody was going to ask me a question about them. Of course, the training at that point for law guardians was so, I mean, it was just watch videotapes, and you were automatically on a panel.
Okay, so kind of setting the stage, back in 1978 when you started, Judge Hartley, tell us a little bit of what family court was like, if you can. Well, I can
I
ask
think
the
for the-
question.
go ahead.
How about this one? Most of the attorneys here are familiar with the Uniform Child Support Standards Act together with the hearing examiners. How was that back in 1978?
Wasn't.
And what do you mean by that?
There was no Child Support Standards Act. There were no hearing examiners or support magistrates at that time. It was a one-stop shop. And we didn't have a whole lot of people on board to help do it. Obviously, I was the only family court judge, the third family court judge in Chautauqua County's history, for which I'm very grateful and enjoyed immensely. But we had an office space up in the second floor of the Jurassic building. I know there are a few of you that remember what that was like. My staff consisted of my secretary, Sheila Raystrick, my court reporter, Phil Sabatino, and I think we had a thriving staff of 3 clerks.
Who was your
for the
chief
whole
clerk?
Noma Nabalski, subsequently Noma Gallagher. She was the chief clerk, and then she had 3 well, they weren't deputy clerks at the time, actually. I think if anyone's familiar with the state system for classifying positions, pay grades, I think the highest pay grade we had next to the chief clerk was a grade 6. I think we had one of those, and the others were, I think, grade 4s.
Who was your law clerk?
My first law clerk was Larry Zobel.
Yeah, but in 1979, did you have a law clerk?
That was the first year that county-level judges had law clerks, and they were only part-time. So I had Larry Zobel was my first law clerk. He left to, when he had an opportunity to become the city attorney in Dunkirk, and then Pat Rice was my second law clerk, then Susan Amsler, and last but definitely not least, was Betsy Stager White. That was the 1 year that I had a full-time law clerk.
And let's talk about the Child Support Standards Act. So they would apply for child support in front of you, and I remember the Standard Act started in 1998. So up until that time, about what would child support be per child? And Judge Claire shaking her head because she remembers that when we would appear in front of Judge Ricotta or judges and they would set it. I think, no, 1988 is when it started. I'm sorry, 1988 is when that happened.
Yeah, that
The
sounds
Child
more
Support
like it.
Standard Act.
And that was after the hearing examiners at that time, because I think they first started in early 80s.
79,
No, that was after, it was later than that.
okay.
It was, Sheila, do you remember, in the 80s, I think, yes. Because by that time, Larry Zobel had been with me for 2 or 3 years, and he went to the city attorney's position, and then he was one of the applicants for that position, which was a full-time position. And in the initial setup of the hearing examiner position, the powers to be, meaning Buffalo and Albany, had provided for Chautauqua County to only have a half-time position for the support or hearing examiner at that time. And I went to Judge Kane, who was the administrative judge at the time, and with the numbers that we had, which for many years were approximately the same amount of cases on a per-judge basis as Niagara County was. And he finally agreed with me that we should have our own hearing examiner. So when Larry was appointed, he was appointed full-time. And there actually was some dissension among the ranks of many people that felt that he was much too young. And there were many older attorneys that, frankly, I felt were looking for a job to take to retire in, and that's not what I was looking for. And I think any of you that have appeared in front of Larry know the type of support magistrate he was. He was one of the original and stayed there until, I can't remember when it was in the early 2000s.
Yeah.
I think when Larry finally retired. So that was one big change that we had during my initial time.
And what about permanency hearings with neglect? How did that work?
There was no such thing. If children were placed with the department, either on an Article 10 or in a JD or PINS proceeding, if the department felt that placement should be extended, they simply filed a petition to extend placement of that particular individual, child, juvenile.
So how would they bring termination proceedings ever?
They did bring a few for a while, but when I first started, there were very few brought before me. And I actually was asked to teach or lecture at a training session for some of the caseworkers for the department. And I was asked why I did not grant termination petitions. I said, primarily because they haven't been filed. And at the time, I'm not sure who was the attorney in charge at Social Services, but we had a long talk and finally got them, the caseworkers, to realize that they needed to do their homework and get those cases ready to be filed. And once they did their homework and got the cases filed with the proper evidence that they needed for a case, primarily to show that they had done their due diligence and had not interfered with or discouraged the parents from attempting to reunite with the family and would work with the family to prepare an appropriate plan for return of the child, then they started winning some of those cases.
And what about juvenile delinquents? And how were they treated?
Well, juvenile delinquents and PINs initially were actually under the same article in the Family Court Act. And I don't recall the exact year, but eventually the legislature separated those two into two separate articles under the Family Court Act. And the role of the law guardian had traditionally been to be more like a guardian ad litem for the juveniles, particularly in JD and PIN's cases. But when they created I think it's Article 7 for the JDs, the legislature made it clear that the role of the law guardian was to represent the child, and it was their job to represent them vigorously, very much like a criminal case. And they were expected to make appropriate motions and discovery and so on.
Now, during your period of time, there were a couple of initiatives that you put together, and can you tell us some of them?
One of the first things that I did when we started in Mayville was to, Judge Hollenbeck had always felt that a pretrial before the actual trial of a case was something that he did not feel worked best for us in this county at that time. When I came on board, I had been used to doing pretrials in the criminal courts, as I had done a lot of work there, and several years I was in the public defender's office. And I felt, and in talking with many of the attorneys at the time, they agreed that having a regular pretrial calendar would be appropriate and would help move cases and the calendars along. And that's how we came to establish a regular pretrial calendar. And in those days, I pre-tried all my own cases, and if the case was not settled at the pretrial conference, we would schedule a hearing date right then. And if it didn't mean that you couldn't settle it afterwards, but that did mean that was when your case was going to be heard, and that's when it was heard. And there weren't a lot of adjournments after that.
Another initiative that you instituted at the Jamestown Boys and Girls Club. What was that?
Yes. Well, for many years, we in Chautauqua County had really no place for non-custodial parents who had become either because of their own fault or on rare occasions, sometimes it was the fault, at least in part, of a custodial parent, but they did not have a place where the non-custodial parents could safely meet with and become reacquainted with their children to reestablish the parent-child relationship. So I have been looking around for some time for different opportunities to create such a setting where we could do that. We looked at what Erie County was doing, and basically At that time, Erie County had just one medium-sized room, basically with 4 walls and a couple of chairs, where they had to meet with their children. Well, we were very fortunate to have, at the time, Rick Sotier was president of the Jamestown Boys and Girls Club, and he and I got together on many occasions and eventually set up a supervised visitation program using the facilities of the Boys and Girls Club. And they had, it was quite a good program, actually. The parent would have to pay a grand total of $5 to essentially join the Boys and Girls Club. And for that, they were able to, every Tuesday night, I believe it was, they had a family night, and the gym, the pool were all made available for the parents to meet with their children. The Boys and Girls Club really got behind it, and they went out and procured a grant which allowed them to buy, I think it was like 6 or 8 brand-new computers, which at that time was quite a bit of money. It's not like the prices you can get computers for now, so they were very fortunate to get that. So that was available for the parents and the children to be able to do things rather than just sit together in a room basically looking at each other.
What did you see your role as a judge up through till 1998?
My feeling had been was that family court is a court, and we were not social workers in black robes. And that is how I attempted to run the court at that time, and to be consistent but not predictable.
So then in about 1998, Judge Claire comes in. Is that right?
Right.
And who was our chief judge at that time? 1998.
Judith K.
And she came out with a new approach for family court. And what was that?
It wasn't family court. It was a broad-based, philosophic approach to justice, I think. It wasn't like a mandatory type thing, but she coined the term preventative justice. And it applied primarily to family court. And the idea being that family court was different than other courts. It had the revolving door of justice. Unlike other courts where the matter was settled and done, I used the example of a boundary dispute. You decide it, and that's the boundary. Or a medical malpractice, you get an award, and it's done. But in family court, it was really never done. You had families, parents and children who were struggling, and you might resolve the case, but instead of it being done, they might come back 3 years later or 6 months later, and before long, their children were coming back. So preventive justice was the idea of breaking the cycle.
And so in 1999, when you took the bench, you had a number of different ideas and concepts that you began to institute over your period of time that you were there. Can you tell us some of the changes that you saw happen in family court and some of the changes that you applied as well?
Well, all told, we probably had approximately 20 initiatives that we instituted during that time, most of which really, I believe, made a difference. The goal was to help people be successful, to help them solve their problems so they could be as functional as possible, so they could be better parents, for children to be as healthy as possible. And that was pretty much behind just about everything. I remember I made I gave you some of them, and I won't remember all of them, but
I have a list.
There, okay. There was CASA. I had never heard of CASA. It was a national organization. New York State sent me to Reno, which is actually where the National Family Court Judges College is. And in 2001, I represented New York State there, and I was the only judge there who didn't have a CASA. I'd never heard of it. So when I came back, I decided that I was going to try to see what I could do, and I called a meeting, and I invited absolutely everyone I could think of. And I remember sitting in the jury room being really sad because no one had shown up. And Frank Bajano came rushing into the jury room and said, "What are you doing here?" And I said, "I'm waiting for people for the meeting." And he said, "So many people showed up, we couldn't do it in the jury room. We moved it to Supreme Court." And I went in, and there were 100 people there. No kidding. And about 90 of them signed up to stay on and help create CASA. And it still is running today for abused and neglected children. We started drug court that Judge Sullivan referred to. We started trauma-informed care. We were the first trauma-informed court in New York State and one of the first in the nation. We had people coming from all over internationally to observe the court and see some of the things that we were doing. We basically insisted on having the daycare center.
Wait, before you go on to the list, can you just tell us a bit of how CASA works, since it's still there, and a little bit of how the trauma-informed care works, and how you got involved with both of those?
CASA is a volunteer organization. It's for abused and neglected children. There are several people in the room who've been actively involved in CASA cases. I don't need to explain it to them.
And can I
but-
also interrupt and say this,
Sure.
too? And as I had 5 minutes with everybody together to try and hear how everybody interacted, one point rang true, and that was Judge Claire said, "Boy, times are changing, times are changing." 1998, you are the first woman judge ever elected in Chautauqua County.
I'm still the only.
And the only. And in 1998, 99, with Judge Claire, or excuse me, Judge Kay, with the new initiatives, judges are now asked to be more proactive with the community, where you might approach and start something like CASA or start something like the trauma-informed care. So that's another huge change. We're becoming asked to be more proactive. So tell us how CASA works a little bit, and then tell us about trauma-informed care, which is still there.
I wanted to say that I felt I was blessed to be a judge when I was. I had full support from OCA. They always supported me in every single one of the initiatives, and really were just very, I don't know what word to use, welcoming in terms of every crazy idea we ever came up with. When we started the youth orientation, which is probably, of all the initiatives, one of the ones that was dearest to me.
And can you tell the audience how youth orientation works and why?
I found youth orientation to be one of the most meaningful things I did as a family court judge. When they started permanency hearings, which I don't think started till about 2006, kids were invited to come to court for the first time ever, every 6 months, so no child was ever lost in the system and languished in foster care for years, as had happened traditionally across the nation in the past. But kids weren't coming to court. And it was their lives. So we started sending them letters that we signed saying, this is your case, and we're having youth orientation day. And again, there's several I see several people out here who have actively participated in youth orientation days. The children started coming to court on youth orientation days, and they would get a tour of the courthouse. They would be told what would happen if they came to their permanency hearings. They met a public defender, they met an attorney for social services, a deputy explained to them about going through security and how the courthouse was a safe place. They were shown the different waiting rooms where their parents would sit, and the process was explained to them. We even had the court translator address them and the court reporter, which actually was one of the kids' favorites. They were always fascinated by the court reporter. And at the end, they each got a certificate of completion for attending the day. It became very significant because the kids would support one another. Every kid who was there had parents who were facing an abuse or neglect petition. And we would see how they would clap for one another when they would come up for their certificates, how they were gentle with the younger children who came, and the questions that they asked. And they were full of questions. When we would sit in the courtroom, which was later in the afternoon, because they were here for a couple hours, and just how the process worked. The end result being that we had one of the highest participation rates in New York State for kids coming to court to actually participate at the end of the 6 months when they had their permanency hearings. It's their lives, they're the ones being most affected by it, and they were being given a voice in the process, so it wasn't just happening to them, but they could be an active participant.
And is that when you had the startling revelation that the kids were hungry? Was that?
Oh, no, that was a different one. One of our initiatives was to do a survey, and we asked the kids 10 questions. It was voluntarily. One-page survey, 5 questions, I think on the front, 5 on the back. And the last question was, what can we do to make your permanency hearings better? And we got a consistent answer that floored us. It was the last thing we were expecting, and that answer was, have food. It knocked us for a loop. We weren't expecting it. We didn't have any money as a court, and we're not allowed to fundraise, per se, as a court. So we thought, how are we going to get food to court? What can we do? So we brainstormed like we did with all our initiatives. We got the different stakeholders together, and everybody was full of ideas and enthusiasms, and CASA agreed to be in charge on permanency hearings days, which we ran twice a month, and see that there was food. And everybody signed up. The court signed up, us as individuals, to bring food for certain Fridays. Tops Market agreed for certain Fridays. Westfield Rotary was a big participant and offered to bring food. But the ones that got me the most, and I mean the list goes on and on, DSS, they were DSS at that point in time, was responsible for certain Fridays, but Randolph Children's Home, BOCES, and the GA Home all signed up to do certain Fridays. And I want to tell you, for kids who were in care themselves at these facilities and were in the food services program, to make and plan the food and then bring it to the court knowing that it was going to be eaten by other kids who were in foster care or had abuse petitions, whatever it was, that was so meaningful. Those kids were so proud to bring that food in that they had made themselves and have it there. We had a dedicated attorney-client conference room that we set aside for what we called snacks and chats, and we used to decorate it on those Fridays with crepe paper and toys and books and activities that were age appropriate. We would give CASA a list, of the ages of the children who were coming in that day, so they could be prepared. And then the kids were told, either before or after or both, their permanency hearings, they could go into the snacks and chat room and talk to an adult about what to expect before they went in the courtroom, or afterwards when they all said, what just happened? And so it was just a wonderful resource.
You also set up mediation as a statewide model?
Yes, yeah. We started a model of mediation, and then the state had come in and said everybody had to mediate, and they weren't aware of our model, and they were going to impose a model on all family courts in New York State, and we said, ours works, and we'd like to keep it, because what they wanted to do was have people come in over several days and then come back before they could agree, and we knew it wouldn't work. The reason it worked, what we did was the spontaneity. People agreed right then, and if you made them come back, it wasn't going to happen. So we brokered a deal with them that they should observe and let us do ours and keep statistics for 6 months, and if they didn't like it, then we would go to this model they were proposing, and they agreed to this, and at the end of the 6 months, they changed their own rules and used our model for the rest of the state.
So you became a national speaker and actually international speaker, going to Prague, Vienna, and what were you lecturing on overseas?
I went to the International Academy of Law and Mental Health in Vienna and in Prague on 2 separate years, and spoke in several other places, mostly about trauma-informed care and the model that we used here in Chautauqua County.
And that's something that's still being used. Can you just tell us a little bit about how that works?
Trauma-informed care is very hard to explain in a few sentences. Basically, it goes back a bit to the revolving door of justice and family court. The fact that if you do the same thing over and over and it's not working, then you're not doing something right. If you expect people to make changes and they're not, and you see the same pattern over and over, what can you do to reach them? And so with trauma-informed care, there were 5 principles. One of them was safety, making the courthouse a safe place for people to come. We felt safe there, but most people who came to family court did not feel safe there. And learning ways to make people feel welcome when they came. And it may sound a little bit corny, and it's, like I say, it's really hard to explain in a few sentences, but I could give you so many examples when you look at it through someone else's eyes. And the point is that it works. We saw significant changes, and we saw people engaging in their cases and trying to make things better, because most people genuinely want their children to have good lives. They want to be good parents, and if you can throw them a lifeline, they're going to grab it and just keep pulling. And that's what we saw happen.
And using that segue of the lifeline and being proactive in your tenure when you were up there, can you tell us a little bit about the Bridget Y or the Yaw case?
That was probably one of the more significant cases I handled, and again, another one that just went on for years. It actually went up on appeal, I think, 7 times along the way with its different stages. There's a lot to it. It involved 4 children they came from New Mexico, and they arrived here in Chautauqua County because there was a relative. Their father, this has all been published, not just legally published, but in newspapers, I guess, across the United States, so I'm not revealing anything that's confidential necessarily. And the children are all grown now. But in any case, he was an orthopedist, an orthopedic surgeon, and basically the girls were being tortured, and they arrived here, and the family member brought a petition in court, and DSS, I guess they weren't involved right in the beginning, but they were certainly actively involved over the years. And one of the first questions I had to decide was whether New York State even had jurisdiction to handle this.
But there were 4 girls,
Yes.
and they were left in a trailer?
Yes, he had a very beautiful home. We saw pictures of it in New Mexico, but he locked the 4 girls in a trailer park that had no furniture, no beds, no clothes, and every other week or so he would show up with pinto beans and
Peanut butter.
Yeah.
And so eventually the kids end up in New York State, and you have to make a big decision as to jurisdiction.
Jurisdiction. So the UCCJEA, Uniform Child Custody Jurisdiction and Enforcement Act, it's a federal law, and basically all 50 of the states have adopted it. And this situation was basically a case of first impression. It didn't really fit into any of the parameters of the statute exactly. I mean, there were things that were somewhat similar, but nothing exactly like it. And this was one of the earlier issues I had to decide in this case. And I just wasn't sure where to go with it. I really struggled.
But they wanted the kids back in New Mexico,
Oh,
right?
they definitely wanted the kids back in New Mexico.
And you had a conversation with the judge down there?
Yes, the father had hired actually a team of attorneys from New York City, from Buffalo, and elsewhere. And that I had spoken with the judge in New Mexico, and there were a number of issues.
Turns out that judge was corrupt.
I had a feeling the judge was corrupt, but I wasn't sure. I mean, I guess I can't say for certain, but he was, we were wondering what was going on there, because something wasn't right. And this had a big impact on how I decided the case. But at any rate, yes, he ended up getting indicted, not on this case, but on, I don't remember, whoever was governor of New Mexico, and there was a presidential election or something.
Bill Richardson.
Yes.
Because you were the
Right.
law guardian, right, Mike?
Right. Judge Sullivan was the law guardian until he was elected, and the case was still going on at that time. And yes, so he was supporting, who was he supporting?
Well,
I can't remember.
He was supporting the judge that was in that case, and the judge in that case was accepting bribes to have other people become judges. But the best part was, when the judge was indicted, the attorney that was representing the doctor became the judge's attorney in his indictment.
Right, yeah.
But that case set the standard for emergency jurisdiction that's still followed today throughout New York State.
Right, the appellate division wrote one of their longest decisions in their history, upholding my decision in which I granted, I granted emergency jurisdiction, and the appellate division wrote a 19-page decision upholding that, and that went up to the Court of Appeals and was just simply affirmed.
And then you also had another case, which was Brooke S.B. And the facts were basically two ladies, they're together, they have a symbolic engagement, they decide to have a child, and then one of them is artificially inseminated, right? And then what happens is they separate, and you have to rule on standing. And tell us a little bit about that. Because that changed the tenor in New York State as well.
Right. There were several cases that went up that had interesting histories, certainly in those years. Brooke S.B. was one of the last cases I handled. That was at the end. And again, times had changed dramatically. You had two women who had a child, and one of those women had done nothing legally to protect her position. Marriage had become legal in New York State after they had the child, but at that time, they did not get married. She did not apply ever for adoption. So she had taken no legal steps. She was actively involved in the child's life. And then when their relation ended, the other mother was not allowing her to see the child. So she sued. It was clear from the facts that she had been very active in the child's life, that the child had bonded with her, and the child did want to see her. But the mother who gave birth was refusing that. The law was very clear. She had no standing. She had done nothing legally to put herself in a position where she had any rights. I felt I had to follow the law. But it was also clear at that point in time that in our current environment, that law was most likely not going to stand. It was a couple years after marriage had become legal, and just the tenor of society was very much changing. So when I made my decision, I didn't give her any rights to visitation, and I said that as a judge in New York State, I was required to follow the law as it existed. And then I wrote that if I were to follow the traditional standard, which I couldn't hear, of best interests of a child, or if I were to look at justice, what was good for this child, that I would have been granting this mother some rights. I felt my hands were tied and that the law was likely to change. So the case went up to the appellate division, and I was affirmed, and then it went up to the Court of Appeals, and I was reversed. And they said the time has come and that we are changing the law, and that, of course, was the first case in New York State to grant same-sex partners visitation rights.
Speaking of changing, Judge Piazza took the bench in January 2015, and what are some of the changes that have occurred since you've been there?
Well, there have been some changes. One change is that family court has gone paperless as of February of 2018, which is a big change. I'm sure Judge Claire, Judge Hartley remember the voluminous files, and when I started, we would have thick files. Now everything is scanned in. I have 2 screens on the bench, and I can hit a few buttons, and I can have petitions, orders, everything else right at my fingertips. And it's made things quite convenient. Paper, after 6 months, the paper is destroyed, so it's quite a change going paperless. It took a little bit of getting used to, but now that's the way it is, and I think it's going very, very well.
Probably big savings on stamps as well, right?
I think so. I'll have to ask Dave Travis about that, but that's been one of our changes. Oh, another.
You notify everybody by email now then as well?
Email is the way.
What are some of your other programs that you've instituted?
Well, there's another program that's been instituted. It's called the Better for Families program. Its shorthand is BFF, and that's a very interesting program. When there's issues of abuse or neglect, if substance abuse or chemical dependency is identified as a factor, what happens is these cases are put on a different track. So a request is made for an assessment on the respondent. So if they will participate in an assessment, and it turns out that they would benefit from treatment, what happens is they are offered a variety of services. There are peer advocates that are in court when we have our calendar for the our BFF cases. That peer advocate can assist an individual in navigating the whole process. If, though, an individual will not participate in the assessment, then the case is put on a fast track. And within 90 days, we have a fact-finding hearing. That way, we're going to have to resolve the issues one way or the other. But the idea is, if we can identify individuals who can benefit from services, and we can provide these services up front load them, so to speak, there's a real benefit to providing services as soon as possible, and that goes a long way to helping with better outcomes.
And they come back every 2 weeks if they're
Every 2 weeks, if there's
non-compliant?
no assessment. I know many of you out there show up every 2 weeks, and I have to make an inquiry. Judge Sullivan makes the inquiry. What's the situation? Will you participate? What are the problems? What can we do to help facilitate it? And
And that's called Better for Families?
Better for Families.
I know the first one I got, they kept coming back every 2 weeks, and I thought it was best friends forever. They just kept coming back.
And clients have said that in the courtroom. And
could
I want to know who works in an office in Albany that comes up with the names of these programs. Trauma-informed courts, your TICs. Better for Families, BFF. They're just throwing those softballs out there to some of the folks coming into our courtroom for the obvious question, like, oh, we're going to be best friends forever. Well, you know, if you don't get your treatment taken care of, we may be.
Well, at least
But they don't stop.
90 days. And another program, and this is really an interesting program, and Chautauqua County was a pilot county, remote temporary orders of protection. As I'm sure many of you are aware, if an individual wants to petition, they want to file a family offense petition, and they're entitled to have a hearing to give ex parte testimony, and the court has to determine whether it would be appropriate to issue any temporary orders of protection. But it can be difficult for individuals to get to Mayville. Maybe they're in Dunkirk, maybe they're in Jamestown. That doesn't mean there isn't a real need for the court to hear what's going on with them and to make a determination as to whether a temporary order of protection would be appropriate. So what has happened in partnership with the Salvation Army, individuals can go to the Salvation Army, and in both Dunkirk and in Jamestown, they can electronically file a petition. And what the court will do is, by Skype, we can then conduct, we can take testimony, and an individual can be in Dunkirk or in Jamestown. They can be providing testimony to the court, and then the court can determine if it's proper to issue a temporary order of protection or not. And this also applies to issues of elder abuse. The Center of Elder Law and Justice is a partner in that process as well. So with technology now, we can streamline this process. Someone can be in Jamestown, I can be, or Judge Sullivan can be taking testimony via Skype. We can issue temporary orders of protection. It's a new program, but I think it's gone very, very well.
And Judge Sullivan, you have a couple things you're working on as well, right?
Well, working on and working along with a number of partners. I think the most important one is Dr. Chasnoff will be coming into the county again, and that's going to be a program where we are focusing on the problems for newborns that were caused by the substance abuse use by a mother during pregnancy. The goal of the project is to, again, using some of the trauma-informed, the motivational interviewing, getting answers from mothers at a time when you can anticipate what problems that child might have 5, 10 years out. Right now, we're dealing with kids who, unless they were born addicted, you may not know for years of the substance abuse that is triggering problems with their development until they're 5, 6, 7, or 8. By that time, you've already missed out on years that they could have been doing some earlier intervention for those children. So we're in the process of developing a plan that will hopefully lead to some grant money that would allow us to bring in a psychologist to deal with that age group, the 0 to 5s, so we'd get a better handle on early intervention instead of waiting until we start seeing the problems at school age.
So this is kind of a casualty that's coming from the opioid epidemic and how it's spilling over into families and how it's affecting everybody?
Well, I don't know for sure on your calendar, but with the neglect cases that are there right now, 98%, I think I've got 2 cases that aren't substance abuse related of the neglects. And looking back at just what I've seen as a change in family court, when I first started, you would have children, and the neglect cases were kids who had been beaten with a piece of wood, shaken, dropped, kicked, burnt with cigarettes, physical abuse that had symptoms and signs that you could see. Today we're getting kids that are coming in, and they're there, and they don't have a clue why they've been removed from their parents. They weren't beaten, they weren't burned, and they don't get that the substance abuse their parents had prevented them from giving them the normal care that's needed. So kids are getting removed, put into foster care, put in with other relatives, and they don't have that knowledge. And that's on the overwhelming cases today, and it's just so, I think you knew what you had to do with kids that had been physically assaulted. I don't think we have a clue yet how we're going to deal with kids who don't even know they were neglected. They don't understand the parents' substance abuse and how it impacted them. And we're going to be dealing with that on top of the kids that are suffering because of use before they were born. So I think change-wise, what we see in the neglects has become more hard to understand because I think the kids are going to have a harder time understanding it. One thing about drug use, they're going to be as silent and secretive as they can, and in most cases the kids don't even know it because if the kids found out, well, they might say something to somebody.
You're also working on some first family legislation?
Well, the first family legislation was passed nationally. New York, we should have been implementing 2 weeks ago. New York got an extension for 2 years, which is going to be really placing an additional check and balance into placements that are taking place for children, particularly the older children that get placed perhaps at a GA home or other similar type facilities. There's going to be a much more in-depth, they'll be back they'll be back in 60 days to determine if the placement was necessary. There's going to be a lot of control and restrictions put on. The goal is to have fewer children in congregate care or in foster care, and looking at all the alternatives, even more distant relatives. So that's a federal legislation that we're working now to implement at the state level, and we have to do that by 2021.
So I was going to add in some humorous stories, but I'm starting to run out of time, so I'm going to go kind of to the conclusion, and that is, I'll start with you, Judge Hartley. For us, what have you taken away from family court, and what would you like to pass on to our current judges that are in family court?
Family court for me was probably the best 20 years, which sounds like a long time when you say it, but from my perspective, it went very, very fast, much too fast. And I recall some advice that was given to me when I was first elected that has always stuck with me, and hopefully I followed it, and that was, now that you are where you wanted to be and in the position that you wanted to be in, don't change. Be yourself and don't change. you got there because of who you are, stay that way. And that was something that was told to me by, at the time, someone politically on the other side, but it's something that I have always taken to heart and felt was very, very good advice to myself. And the other thing that I think I tried to pass on, and that is to be aware of the younger attorneys coming in, and so that they can learn from us and hopefully show them how courts, demeanor, dress, everything, it all goes together to make a system that I think really works well here in Chautauqua County, and I think it is in good hands to continue to do so.
Judge Claire, you've seen an awful lot of cases during your time that you were there, laughed with the people, cried with the people, had your ups and downs. What have you taken away from family court, and how has it changed you, or how has it affected you, and what advice do you have to offer to our new judges? I was going to call you young judges.
I can get away with that.
I think I personally experienced tremendous personal growth during the years that I was on the bench, and I was always, always learning new things. And there are certain things that I took away in response to that I think are really key for me now, just, I guess, in terms of my belief system. One is that all of us as human beings are capable of change. I absolutely believe that with all my heart. And I saw that all the time in family court. People changed. People turned their lives around. For many of them, it was maybe the scariest thing they'd ever done, and certainly the most courageous thing they'd ever done. And it was inspirational to watch, to see people become better versions of themselves, to go out in the community, and this is, for me, one of the most rewarding things of being a judge, and to go to a restaurant or a gas station or a drugstore and have people come up to me and say, "Hi, remember me?" and then tell you some story of how their lives have changed. And over time, I came to realize that the biggest thing we could give people at family court, and I believe this was, in fact, the case, was that we gave people hope. And I saw family court as a place of hope, not as a place of tragedy, a place where people could maybe find the tools to get a better life. In terms of advice, I don't need to give a lot of advice to these two gentlemen who certainly know all the important things I think about being a family court judge, except I'd say one thing. This is something that I learned, and I have not forgotten it, and that is everything you do, no matter how small, when you are a judge, can make a difference. And you're never, ever aware of the impact of that, sometimes till years later. And the example I'll give is, if you remember Barb Kubera, she was our drug court coordinator. She came up to me once and she said, "I have a story to tell you. I ran into a man on the street and he came up to me and he said, 'I'm so glad to see you. There's been something I've been wanting to tell Judge Claire for years, and I've had no occasion to see her.' He said, 'But maybe you can tell her.' He said, 'One day I was in court, and I was the father of a child, and the mother was there being arraigned on a child neglect charge, And I was there because the other parent, as a courtesy, gets a notice and has a right to come to court. And he said she was, getting sort of reamed out for various things she had done, and the department was, talking about all these things, and the judge was upset, and all these things were going on. And he said, I was just sort of sitting back, really sort of enjoying it all, and chuckling, because he said I was getting my jollies watching this happen to her. He said, and all of a sudden, Judge Claire turned around and focused on me, and she said, sir, you seem to be enjoying this. What have you done lately to be a good parent to this child? And he said, that was all, just that one sentence. He said, but I went home and I thought about it, and I realized I hadn't done anything. And he said, that was the day I started to change, and it was very small at first, but over time, he said, it became a really big deal, and I became a different person. And it seems hard to believe you would change somebody with just a simple sentence, but maybe something you say or do gets them thinking, and you just never know. I don't even remember this incident. But when Barb told me about it, I remember just feeling sort of moved and thinking, we never know what our actions, what impact they're going to have. And I'd say hold on to that thought, always.
Judge Piazza, where do you see family court heading?
Well, there's a saying, the more things change, the more they stay the same. And I remember practicing in front of Judge Hartley, practicing in front of Judge Claire, and a lot of the issues remain the same: abuse, neglect, custody, visitation. But what has changed, at least for me through the years, is that we have so much more knowledge. We have so much more insight. You started the ball rolling with the trauma-informed care, and we have such insight now as to how trauma impacts everyone involved in the family court system, and it's on so many different levels that's so very important. And what also we have insight and knowledge as to chemical dependency. It is just so insidious. It does not matter where you're from, what your economic place is. It can affect everyone. And what I didn't realize, but now I've had some education on it, is that it affects the mind, the chemicals in your brain, the physiological effects, to the extent that we didn't know. I can remember, and you probably remember this as well, at a seminar where they would show the brain chemistry and how you'd think to yourself, how can anyone do this to themselves knowing they may lose their family? Now we understand that they can't help it sometimes. It is just such a strong force. And in fact, we were taught how to use Narcan. And so what I think we need to look towards in the future is that we have a better insight to so many things now. We need to use what we've learned, and we need to use it to address some of the same issues, but we need to take a new approach and use what we've learned to try to help folks, because many of the problems are the same, but our insight and what we do to address those problems can change with the new knowledge that we've gained through the years.
Judge Sullivan, in conclusion, where do you see family court heading?
Well, I see us obviously taking on that much greater role than Judge Hartley was even offered the opportunity to do, and that is where it was rules and laws where we become more of the social work, and there has to be, because the problems we face, we can't be just relying on the rules, the statutes. We've reached a point in society where people are coming to us because they can't solve their own problems, and the law isn't always going to be the answer. There has to be more of that interchange, and I think we've come a long way in bringing family court more into the social work area. I had an opportunity to be trained in the trauma-informed court, and to go to other courts, being assigned to other places, and finding other counties where they haven't been. And it's amazing when you'll have court staff telling you, oh, this person always does this, always, you know. Well, you get them in front of you and you give them a little bit of an opportunity, you know, show some empathy and let them have a little bit of a chance to say what's going on in their lives instead of standing there and being handed a sheet to come back in 2 months or whenever the pretrial is going to be. And they end up blowing off some steam, and then they leave. And I had court staff in other courts look at me like, what did you do? Do you hypnotize them? I'm like, no, I gave them a chance. I empowered them a little bit. It wasn't going to change my decision, but at least they felt they had a chance to speak. And I think we're moving in that direction, and we have to. On a couple of other notes, we talk about change in family court. I was very fortunate. I had a turnkey operation when I got elected. I had Bev Ungerer was there as clerk, and Gail Jackson was there as secretary. So the most immediate change, I'm not sure where she's sitting, Gail will be leaving us on October 30th. She's retiring. And I want to have everybody, if we could, just thank her for helping 2 of us do our job. And I know we ran out of time for the comical stuff, but I've got to just tell one story, if you don't mind. Judge Hartley talked about how when he was doing his job, he had to do both the support, both the custody. Somewhere along the line, the state of New York decided we're going to split those 2 things up. We're not going to have paternity and custody getting decided by the same person as handling the custody visitation. So 6 months ago, a year or so ago, I have a case in front of me. It's a neglect, and I have one of the attorneys asking to have his party dismissed from the lawsuit because paternity hadn't been established yet. And we've heard about how since the last couple of years with the 2 new judges here, we've had the opportunity to go paperless. So on my computer, I can pull up the entire file. And I look down, and the 4th item on this screen is the DNA test. Like, well, you know, I can process and move this thing along a little quicker and at least know if I have to dismiss anybody. So I pull up the DNA result, and I'm looking at it, and I say, well, Mr. So-and-so, your client is still going to be involved. I can't do anything officially yet because it has to go back to support magistrate, but I have the DNA test here, and I'm looking at 99.996. And my clerk, Amy Groves, is whispering in a very loud whisper, "You have the wrong one! You have the wrong one!" And I'm like, no, these are the numbers. I'm looking at them right here. She goes, "You have the wrong dad!" And as she's telling me this, I'm looking out, and there's, first of all, the guy that I've just told him in my best Steve Harvey impersonation, "Miss Columbia, you are the father." He is high-fiving, he's fist-pumping, he's leaning around the table, shaking his finger at the other side, telling him, "I told you so." I then have to say, "Sir, I've made a mistake." 4 items down was the other DNA test. They tested 2 gentlemen at the same time. The gentleman over here is the father, you're not. Dead silence on this side. Now this side, now they're literally high-fiving each other, fist-pumping, leaning around, shaking at him. He storms out. And I'm thinking, oh, that was a really great example of trauma-informed. Up to that point, I had nobody leave my courtroom screaming. This guy's out there. I'm thinking, oh, he's going to find my car. They told me later what happened is in that minute or two, that it took him that long to process the fact that she had told him he was the only person in her life, that he clearly was the father, and he believed her so much that he married her 3 days after the baby was born, which meant he had no rights at all because there was no presumption. And he processed that in that minute, and then he stormed out. So he fortunately wasn't mad at me, though it was a pretty good mistake. And you know, as I think Judge Hartley said, don't change who you are. Sometimes there's a few little things that if you can control them a little bit, like if you've got a sense of control them a little bit, and I'll try to work on that so that I don't do another Steve Harvey with anybody while my terms go on.
Thank you, everybody. This concludes our proceedings.
It is now.
Thank you very much.
Wow. This clearly, thank you to all the judges, all 5 of them. This was a moment in time for the students who came. You just saw a unique experience of having over 40 years of family court justice continuous, and it's fantastic. And I just want to thank you. I want to thank specifically Judge Cass for pulling this all together, making it light and lively, and Judge Sullivan, your last comment was clearly a concluding one.
I was afraid it was going to conclude my career.
Wow. I'm not sure we could top that one. So I want to thank you very much. I want to thank all the participants, but there's still one more hour of continuing education left. We're going to convene downstairs, and Nellie Drew is going to tie in both Antonio Brown and Alexander Mogilny and the Buffalo Sabres and the Pagulas, all one place, one time, and you get an hour's worth of credit for that. And I am just thrilled. So lunch is downstairs. We start. And thank you, everybody.
Thank you.
Judge Claire. Thanks. Awesome job.